Hello everyone and welcome to our webinar, The Law Demystified, Mental Health Act 2001 and Persons with Disabilities Act 2008. My name is Farisha and I would like to thank everyone so much for joining us this afternoon. Now, before we start, we just want to let everyone know that this webinar is being recorded and that the recording will be made available later. We have also allocated time at the end of this session for audience questions, so please feel free to submit any questions through the Q&A box. Now, I would like to introduce the speakers for this webinar. The first speaker of the day would be Thulasy, who is a litigation lawyer and partner of the firm Law Office of Suppiah. As a committee member of the Kuala Lumpur Bar, she has been the chairperson of the Gender Equality and Diversity Committee for 2 consecutive terms, and amongst other programs, conducts the GEDC's monthly pupils introductory sessions on the subject of unconscious bias, prejudice, and discrimination in the workplace. Most recently, Thulasy co-annotated the Mental Health Act 2001, which is part of the Annotated Statutes of Malaysia series. Our next speaker is Gan, who is a partner at Mahweng Kai and Associates, and he practices in the area of general litigation. Gan has also co-annotated the Persons with Disabilities Act 2008 under the Annotated Statutes of Malaysia series. He is also the author of Contempt of Court in Malaysia, Practice and Procedure, which was published in April 2002. Outside of his work, Gan is also an avid board game collector. Our last speaker for the day would be Anne, who is the founder of the Inclusive Outdoor Classroom. It is a community project championing for inclusion for persons with disabilities where no one is left out. She is a board member of the World Forum Foundation USA and a speaker at local and international conferences on disability and inclusion. She was also conferred the title Wira Awani for her work around inclusion. The Inclusive Outdoor Classroom was also recognized for their work championing children's rights internationally. Now that the speakers have been introduced, I welcome Thulasy to kick off today's session.
Hi, good afternoon, everyone, and thank you, Farisha, for that introduction. Just give me a couple of seconds to get my screen up and just set myself up, yeah? Okay, so I am also going to time myself and make sure I don't take up all of the time, because I want to make sure my co-speakers who have more interesting things to say also talk. So today, first of all, I'd like to thank LexisNexis for the opportunity to discuss this act, just at least for about 15 minutes. It is not without its controversies. It is I think mental health legislation across international jurisdictions, not just in Malaysia, is one of the most controversial pieces of social legislation, some might even say, because it regulates involuntary admission or detention or treatment of a person in a psychiatric facility. Now, to sort of ensure that I'm delivering that with some impact, it means forcibly admitting or detaining someone in a psychiatric facility, right? So forced hospitalization means admitting and detaining adults to hospital for psychiatric assessment or even treatment in some cases against their will or without their consent. Now, this challenges an imperative concept in modern clinical practice or even human rights philosophy as we understand it, right? That of informed consent. So on the one hand, some of you may be thinking or contending that there is always an absolute requirement, absolute, meaning without no condition for exclusion, for informed consent in all circumstances. In a utopic world, in an ideal world, that is exactly where I would also stand, right? The truth is, whilst it is important as a moral principle, this may not always be practical or safe, for a subject in question or for the people around this person. The justifications for limiting autonomy rights include the prevention of harm to a person himself. So this, you would call it paternalistic in nature, or of harm to others. Some argue that such an approach is justifiable only when the decision-making capacity of a person is completely impaired or significantly impaired, such that the choice being overridden is essentially going to be non-voluntary. Now, another angle to this discussion would be the intervention to prevent harm to other members of society is justified because interference with a potential assailant, someone who is considered to be mentally disordered, and we'll discuss the definition shortly, preserves both the autonomy and the safety, consequently, obviously, the rights of the members of society who surround him, right? So a sound legal framework, usually in the form of a mental health legislation, in Malaysia, that would be the Act, is necessary to ensure that we define terms clearly, we restrict circumstances when a person is involuntarily or forcibly detained on the basis of psychiatric grounds. A balance of obviously has to be achieved between having a law that is necessary or that empowers the relevant officers or relatives of a person to the needs and risks posed by a person considered to be suffering from some form of mental disorder, but who does not consent to any form of psychiatric intervention or other necessary assistance this person might actually require, right? So the law, however, has to also appropriately constrain any possible abuse or exploitation, because it does violate a fundamental principle of law, right? That you will not be deprived of your personal freedom or right to autonomy unless there is good reason to do so, and obviously due process of law. And so that is one of the reasons why we are here today. I hope you will gain some insight into the mechanism or machinations of the Mental Health Act 2001. The Act only came into effect on 15th, so let me get the date right, 15th June 2010, some 9 years later, because it had to work in conjunction with the prescribed regulations under Mental Health Regulations 2010, right? So it only came into effect in 2010. So before the Mental Health Act even came into effect, and that was in 2010, the Malaysian courts had already demonstrated a rather conservative approach when determining applications filed for declaring a person as being mentally disordered or mentally impaired. One example, I don't have the case on the screen, but I'm just going to read it out. This example of a case called Wong Kim versus Loh Kim Fo. The High Court actually conducted its own preliminary inquiry. And so you'll notice that it's not on the screen. So Wong Kim and Loh Kim Fo was a 2003 case before the Mental Health Act came into effect, right? So the High Court took it upon itself to conduct its preliminary inquiry and found the 90-year-old man, the subject in question, who had actually been diagnosed, and it's unchallenged, with Alzheimer's, right? The court, on the other hand, found the subject to be able to speak freely and fluently. He was cooperative and coherent, able to answer questions that were posed in the main to test his memory and discernment of events, and so found that he was completely normal and that there was no sufficient prima facie evidence, and dismissed the application. So it is a very conservative approach, and they're very jealously sort of guarding the precepts of not declaring someone mentally disordered willy-nilly. So when considering cases involving the apprehension of a person suspected of being mentally disordered, or involuntarily admitting, detaining, possibly ordering psychiatric treatments for this involuntary patient, it's necessary to have a clear guideline or definition for what constitutes mental disorder and who can be legally declared mentally disordered. And this, I think, tradition has started even before the Act came into play. And from there, of course, limiting the powers granted to the courts, as well as, more importantly, the relevant clinical medical professionals, even police officers and social welfare officers, as to when they are allowed to exercise their powers under the Act. So if you notice on section 2 defines mental order as any mental illness, arrested or an incomplete development of the mind, psychiatric disorder. There are cases, of course, that rely on section 51 that clearly defines what mentally disordered person is under our Act. in Mei Chen, the Court of Appeal stated that the law requires that an inquiry must be held. And of course, the court has taken it upon itself to conduct its own preliminary inquiry even before a formal inquiry needs to be ordered. So an application can be dismissed in limine right at the start if the court finds that the subject does not need to be formally inquired as to his mental soundness, right? We've also got a section 85, as to what the definition of mental disorder excludes. I find that this is also noteworthy. Section 85 is meant to be a catch-all of sorts. It may be that some of the terms that you see are not politically correct or appropriate given the advances made in clinical and medical understanding of mental health today is, but what it does do is ensure that any references to terms like lunatic or mental person, lunacy in any other laws are also covered under the Mental Health Act. Now, what the definition of mental disorder excludes, interesting, I wanted to talk a little bit about this. The definition excludes, of course, very importantly, certain things like promiscuity or other immoral conduct, which is not necessarily defined. And this is something that I find has not been explored in cases either. Sexual deviancy, and the rest you can read on your own. But I wanted to point out an interesting thing about the term sexual deviancy. Now, you might think that, well, that's a good thing, right? Because if you are familiar with the penal code, section 377A, which outlaws, in essence, homosexual relations, right? The last thing we would want is for anyone who identifies as, non-heteronormative or non-heterosexual to be, for whatever reason, committed to an institution on account of sexual deviancy. Having said that, the UK, an observation for you to consider, the UK had previously, they had a 1983 Mental Health Act, which was then amended and reformed. And in 2007, whilst their old act included, precluded or excluded sexual deviancy from their definition of mental disorder, actually, they removed that exclusion. The argument being that in modern times, they don't expect anyone to misuse the term to target certain groups, especially those identifying as LGBTQ, for instance. And an argument was also made that, since sexual deviancy has been excluded, they can now appropriately deal with, pedophiles, for instance. That's arguable either way. I thought I'd tease you folks into thinking about how excluding sexual deviancy in our country would impact us, given our socio-cultural dynamic. One is, of course, 377A, and then the second, something for you to think about, child marriage, right? So the Act limits who is allowed to make admission orders of a patient into a psychiatric hospital. Today, of course, I'm only going to be focusing on, and I'm running out of time, on the second and third, that is orders made by medical officers and RMPs, registered medical practitioners. And of course, with a focus on involuntary admissions through section 10, right? So section 52 is actually one of the most common applications because it usually involves elderly persons or senior citizens. You're talking about relatives who are concerned, again, if you're living in a utopic world, who are concerned that someone in their family is unable to manage himself or his affairs and is refusing assistance or treatment or to enable his relatives to sort of manage his affairs, right? And so they make an application to court pursuant to section 52 to have that relative or subject declared as having a mental disorder so that appropriate actions can be taken. So the court is empowered to do this, and as I said earlier, they are very conservative in how they make such a determination. Usually, a preliminary inquiry is made before, and actually, a more thorough formal inquiry is made. Most thorough formal inquiry would usually entail requesting for psychiatric assessments and reports to enable the court to make a determination as to whether someone is actually mentally disordered, right? So there's quite a few cases. We talked about Wong Kim and Loh Kim Fo earlier. A few other cases of interest would be the case of Gary Lim. Gary Lim was quite interesting because despite the fact that the subject had at least 5 different reports which assessed him, and these were unchallenged, they all agreed with one another that he was, what did he have? He suffered from dementia, right? However, the court, in its preliminary inquiry, based its determination that he was perfectly normal and capable of managing his affairs because there were surveillance reports showing that this person was going out shopping for groceries, he was paying for fuel, having breakfast, and so able to run his daily life, right? So they did not find that he needed to be sent for further examination, and the application again was denied. In another case, I think Tan Guek Tien, the subject's dementia was proven to be irreversible. My apologies. The effect being that his dementia was affecting his memory and intelligence and judgment and ability to take care of himself. And so in this case, the court did find that he was going to be declared mentally disordered for the purposes of having his relative intervene on his behalf. Okay, so involuntary admissions subject to an application made under Section 52 would then result in courts possibly making further orders pursuant to Section 55, as long as there's sufficient evidence. Evidence can be in the form of affidavits, statements from relatives, medical, psychological, or psychiatric assessments as well. Now, this is where the meat of, our interest is really in admissions or of people who, in effect, do not want to be apprehended or admitted into a psychiatric facility. The law actually enables a police officer or welfare officer to apprehend someone they have reason to believe is mentally disordered. The subject is required to be produced for assessment within 24 hours, so it's not indefinite. There are limitations built into Section 11 to prevent abuse. And subsequently, an MO or an RMP will have to make an assessment as to whether this person can be declared mentally disordered and make follow-up orders pursuant to that. All right, so it is regulated between Sections 11 and Section 14. Another interesting provision under the Act would be Section 12, also 13. Now, in 12, both are intended to protect subjects who are not legally declared as mentally disordered, but there is suspicion that a vulnerable person, by virtue of them being unable to defend themselves, for instance, is mentally disordered, and that places them at greater risk or harm than someone who is not mentally disordered. In effect, what these two sections are intended to do is to rescue someone who might be at risk, who is suspected of being mentally disordered, even if they are not legally mentally disordered, right? So I will discuss the cons of this shortly because I am running out of time, so I'm going to skim through some of these sections. Okay, Section 10 of the Act allows a swift process. Now, this is, of course, done by a relative. Section 11 is apprehension by an officer of the state, right? Section 10, on the other hand, allows a relative, only a relative, and the definition for relative is also in Section 2 of the Act, to get help for people who are suspected of being mentally disordered, essentially to admit them against their will in a psychiatric facility. So this is where we need to be cautious and consider the wider implications of the law, because we're essentially allowing a relative of a person to apply to court to admit and detain a person against his will, right? So put that way, I'm sure you can appreciate why it's necessary to have limitations placed within the Act. So procedurally, I would say there is enough in the Mental Health Act. Now, the practicalities and our observation on that is another discussion altogether. But procedurally, it appears pretty sound at the start, which is that relative needs to have grounds to substantiate the application. And of course, it needs to be supported by an MO or an RMP's assessment, a psychiatric assessment of the involuntary patient, right? There is, of course, a review process, meaning even if the patient is not agreeable to the recommendation made by the MO and RMP, they can appeal, except, of course, the question that arises is who's expected to appeal on behalf of the subject. Certainly not the relative who's making the application. Okay, so I'm sorry I've had to scream. So I'm just going to stay on the previous slide just so you can read through. But what I'd like to sort of discuss is, now that you've had a sort of brief overview of some of the key provisions, Section 52, namely Sections 11 to 14, and then Section 10 for involuntary admissions of any subject on the basis of a mental disorder. Section 11 allows a police officer or a social welfare officer to apprehend anyone they have reason to believe is mentally disordered. Okay, so who is deemed by the officer to be dangerous to himself. The Act doesn't necessarily define what is dangerous. So I'm just going back to Section 11. And I have not found cases that give any framework or guidance as to when it is reasonable to believe someone to be mentally disordered. The interesting thing is under Section 13, all right, 13 sub 4, it imposes a duty on police officers to report cases of neglect or cruel treatment of a suspected mentally disordered person, which may come to his knowledge. So in reality, the way the justice and enforcement systems in Malaysia work, I would say, how practical is this? Because a police officer may really just disclaim knowledge and deflects his duty or any liability for violating his duty, right? So somewhat toothless. Again, something to think about. I do not have answers because we do not have any cases that discuss this. So what comes to mind is, for instance, the case of Bella, if you are familiar with the Siti Bainon Rumah Bonda case, right? The teenager who was, I think she is officially a Down syndrome patient, but for now, at the material time, I don't think she was properly diagnosed. She was being neglected and abused by, the case is still being determined. So the charges against the Rumah Bonda owner Siti Bainon are for neglect and abuse charges under the Child Act. Now, the police only commenced investigations after the other residents had come forward with incontrovertible evidence that she was being abused. So the question I suppose I find myself asking is, based on the plain reading of, the Mental Health Act, specifically sections, 11 and 13 sub 4, a police officer really is empowered to take action as long as one of the residents came forward and just reported it. Right? They didn't need to have, video evidence as was produced in the case of Bella before they actually took action and finally charges were brought against Siti Bainon. So again, question mark, does Section 13.4 actually really work in reality? Concerning Section 10, questions that from an application and enforcement standpoint that I'd like to sort of raise for your consideration. The court will most of the time be relying on the assessments of the applicant relative and the clinical or medical professional, right? With that in mind, I'd like to sort of contextualize it just a little bit, right? Consider the mental health workforce in Malaysia. These statistics are based on a 2018 paper, Mental Health Services in Malaysia, which was published in the Taiwanese Journal of Psychiatry, Taipei. So yes, between 2001 to 2018, we see that it's improved, except even today, not today, but as of 2018, we have, on average, at least one psychiatrist for every 100,000 people in Malaysia. However, interestingly enough, most of these practitioners are actually based in urban KL, right? With the best ratio of about 5 psychiatrists to every 100,000 people. But in Sabah and Sarawak, they barely have 1 psychiatrist, like just half of them, and we hope it's a top half, right? So I guess the comment I would like to sort of make is, based on these statistics, we are actually far from the WHO recommended ratio of 1 psychiatrist per 10,000 population, far from it, right? These statistics that you see on the screen are for every 100,000 people, right? So overall, our mental health resources are very low, especially when compared to other more advanced countries like Germany, Sweden, Finland, for example, right? And as I understand it, and it's based on this paper, there are only 4 large mental hospitals, one in the north, which is in Ulu Kinta, south, Johor Bahru, one in Sarawak, and one in Sabah. They provide typically long inpatient services catered to those who have become too disabled to live in the community. But it is only, out of these 4, only 2 have forensic services, meaning only 2 technically, as far, this paper was written in 2018, actually have the people whom the courts will generally rely on to provide them with the reports and assessments, right? So, so we've got a long way to go, right? The paper notes, for instance, that there are very few managerial posts in clinical service, and in reality, practitioners are not trained to handle administrative tasks like the one that, it sort of, the Act imposes on them. So that increases their burden. It's not clinical necessarily, the Mental Health Act. It's examination-based assessment, and it adds to their workload, and it's not something the mental health infrastructure, it would seem, is able to handle. And the truth is, we do not have sufficient data to sort of even make that observation and comment. So yeah, so I'm not able to go through the rest of these slides. So if I can conclude though this session with some questions that I'd like some of you to walk away with and think about. And given what I mentioned earlier about the lack of information, data, and statistics on, let's forget about the Mental Health Act and how it applies, but admissions and people who need it but who are not necessarily being admitted into facilities. So knowing that the absence of data, of course, does not mean that we do not have anything actionable, right? We can and should, in fact, be making space for anecdotal sharings of either persons who've been subject to proceedings under the Act, or any proceedings where they've been there's been an attempt to have them mentally declared as mentally disordered, or otherwise people who have experience with the mental health infrastructure in this country, and how this Act is useful, or does it need to be more nuanced in its application? So, questions for you to think about: is our mental health workforce sufficient or adequate to handle applications arising from this Act? Do you think our justice system is sufficiently guided? So I recall, as I was annotating the Act, I have I had this piece of paper where I was keeping track of all the terms that I needed to go and look for cases on. Terms like best interests of the patient, what is dangerous, what constitutes apprehension. Apprehension under the Mental Health Act, should it be the same as apprehension as when we think about criminal charges, for example, right? Obviously not, you would think, but we don't have anything that in any way guides us or defines these terms when it comes to the Act. So there are many such terms that and it was quite disappointing as I was trying to annotate the Act. And of course, ultimately, overall, do you think the Mental Health Act is still a humane and practical one that serves its purpose? So yeah, thank you. I apologize for taking up too much time. Chong Chieh, over to you.
Thank you, Thulasy. Thank you for the insights given with regards to Mental Health Act. I'd like to thank Farisha for the warm welcome, and also thank you to all participants for taking time to attend today's talk. Let me just share screen. Yeah, so I will continue with Persons with Disabilities Act, or known as PWD, and I'll be giving an overview of this Act. So let's go to the background of PWD 2008. So how the Act come about? So in 13th December 2006, the United Nations General Assembly adopted the UNCRPD, which is known as the United Nations Convention on the Rights of Persons with Disabilities. And in April 2008, Malaysia signed the UNCRPD. And in 7 July 2008, the Persons with Disabilities Act, or the PWD 2008, came into force. And in July 2010, Malaysia ratified the treaty. So in line with Malaysia being a state party to the UNCRPD, the objective of PWD 2008, or the Act, is basically to provide registration, protection, rehabilitation, development, and well-being of persons with disabilities. The Act also establishes the National Council for Persons with Disabilities. And the primary function of this council is to oversee the implementation of national policy and national action plan relating to persons with disabilities in Malaysia. The operations of the Act is overseen by the Minister of Women, Family and Community Development Ministry, which is currently headed by Datuk Sri Nancy Shukri. Section 3 to Section 19 of the Act are provisions relating to National Council for Persons with Disabilities, dealing with issues such as regulations, meetings of the Council, functions and powers of the Council, and responsibilities of the relevant ministries. Whereas Section 20 to 25 of the PWD deal with registration of persons with disabilities, which also includes provisions on the appointment of the Registrar General. Section 26 to Section 40 provides for the promotion and development of the quality of life and well-being of persons with disabilities. So the examples here are public facilities, amenities, services and buildings, public transport, education, employment, information, cultural life, recreation, habilitation and rehabilitation, and also health. So technically, PWD persons, they have access to all these facilities that's provided under the Act. So since the topic is on PWD, so technically, what's the definition of person with disabilities under the Act? So it includes those who have long-term physical, mental, intellectual, or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society. This includes those who are blind, deaf, physically impaired, speech impaired, or who have learning impairments. However, it has to be noted that this definition is not exhaustive, and courts from time to time will actually come up with their own interpretation on how do you interpret people with physical, mental, or intellectual and with sensory impairments. So in order for someone to qualify as a person with disabilities and to be afforded the protection and rights under the Act, the person has to be registered with the Registrar General for Persons with Disabilities and issued with the card OKU. So technically, someone with disabilities, they can actually go to the Jabatan Kebajikan Masyarakat to make the registration. And of course, the criteria for registration here include the persons or person who have to be a Malaysian citizen and certified by medical expert or government medical officer or a private medical officer registered with the National Specialist Register of Malaysia or Malaysia Medical Council. With that report and being a Malaysian, and if certified that someone is a person with disabilities, then the Jabatan Kebajikan will actually issue the card OKU. So what are the protections and rights provided for under the Act? So for example, I'm not going through all the sections, but I'm picking up just a few examples for illustration purpose. So for example, here there's access to public facilities, amenities, service, and buildings. So persons with disabilities shall have the right to access to and use of public facilities, amenities, services, buildings on equal basis with persons without disabilities, but subject to the existence of emergence or such situations that may endanger the safety of persons of disabilities. So here, under section 26 sub 1, if everyone can see that I've actually bold shall have right to access to. What's the definition of shall have the right to access to has not been defined in the Act. And all these are still subject to the court's interpretation and making cases or decisions to actually interpret what it means. So this is also one of the flaws of the Act. So in the event if persons with disabilities do not have the right to access to these public facilities or even amenities, so what action can be taken against, for example, the building owner who doesn't actually provide all this? The other protections or rights given under the Act will be access to employment. So under section 27, persons with disabilities shall have the right to access to employment on equal basis with persons without disabilities. And the employer shall protect the persons with disabilities and to provide a just and favorable conditions of work. There's also a section on habilitation and rehabilitation, meaning the council or private healthcare service provider and even non-governmental organizations shall take effective and appropriate measures to actually assist or enable persons with disabilities to attain and maintain maximum independence so that they can participate fully in all aspects of life. Again, the question here arises, what is effective and appropriate measures? This phrase, they are not defined in the Act. So in the event this council or even these bodies do not take effective and appropriate measures, so what's the penalty against them? The government, under section 38, the government shall provide the necessary lifelong protection and social support system to ensure that the welfare of persons with severe disabilities remain unaffected after the death of their parents or their caregivers. So again, the Act is very noble, very commendable, whereby there are protections given where the government shall provide necessary lifelong protection. But again, what's the definition of lifelong protection and social support system? All these are remain unclear. So someone holding a OKU card. So what are the assistance that's currently provided for? This list is not exhaustive. Like for example, financial assistance for entering local public higher education, higher education institution, polytechnics, or even community colleges. Certain states, they are giving monthly general financial assistance, tax relief of 6,000 to PWD, 3,500 for spouse of PWD, fee exemption to register and renew company, fee exemption for passport, reduction of motor vehicle license fee and road tax exemption, 50% discount for all public transport, and fee exemption for my card replacement. So this is a case study on which was decided at the Court of Appeal level, whereby the appellant is an OKU charged for trafficking 242 grams of cannabis. He was convicted and sentenced to mandatory death penalty by the High Court. Dissatisfied with the decision of the High Court, he appealed to the Court of Appeal against both the conviction and sentence. And the Court of Appeal, in overturning the decision of the High Court, made some wonderful remarks and also insights as to what kind of treatment should be given to an OKU being charged for criminal offense. So the Court of Appeal held that the appellant is not an ordinary person, but has a disability of intellect or mind. And the High Court trial judge did not do anything to ensure that the appellant who falls into a class of persons with mental disability can meaningfully participate in the trial process. The court or the High Court should have taken judicial notice of the fact that the appellant was a PWD with mental disability. And the fact that the appellant has given unsworn statement shall not, in this case, shall not be given less weight, for that is the only way the appellant is capable of giving evidence. So what's the difference between giving an unsworn statement and a sworn statement? So a sworn statement is a situation where, let's say, for example, I'm being charged and I'm giving a sworn statement. So my evidence can be cross-examined by the opponent or the other side. An unsworn statement is whereby someone giving evidence or giving statements from dog, but it cannot be cross-examined. And if we all can remember the case of Anwar Ibrahim's second sodomy trial, he has actually given unsworn statement. And what's the danger of in a normal situation whereby someone or accused is giving an unsworn statement? So what is the disadvantage of that? An unsworn statement is whereby the evidence is of could be less or no probative value, and lesser weight will be given to that evidence by the court. But in this case, whereby an OKU is being charged, a different treatment has to be given for the evidence, even though it was given as an unsworn evidence or statement. So in this case, the Court of Appeal actually held that it's a miscarriage of justice if an accused with mental disability is treated the way a normally functioning person will be treated by the criminal justice system. Hence, extra precaution has to be taken when an OKU is being charged and being tried. So in this case, the Court of Appeal set aside the conviction and sentence of the appellant. So what are the flaws of PWD or the Act? So like what we have said, and we all know from a lot of debates and even reports, the lack of enforcement. There are no provisions for remedies and penalties, and PWD has been described to be toothless. There's no forum for dispute resolution. So hence, there's lack of justice for the persons with disabilities to actually seek any recourse in the event they suffer an injustice, as if any of the organization or bodies doesn't actually follow the provisions of the Act. So this is unlike in Australia and New Zealand. There's an establishment of human rights commission which resolves disputes by conciliation or settlement following complaints. And in UK and New Zealand, there are tribunals where they act as an alternative forum to resolve disputes. The PWD 2008 is also, or has provided a very narrow definition of person with disabilities, the definition of person with disabilities. It only covers long-term disabilities, which shows the lack of inclusivity. In comparison with other jurisdictions such as UK and Australia, the definition of disability includes past, present, or future disabilities of a person. There's no definition of discrimination, harassment, or victimization that appears in PWD 2008. This is unlike the Equality Act 2010 in the UK and also the Disability Discrimination Act 1992 in Australia, whereby they have provisions for direct discrimination, indirect discrimination, harassment, as well as victimization. So what's next with regards to the Persons with Disabilities Act 2008? So during the 2002 national level International Day of Persons with Disabilities, the Secretary General of the Ministry of Women, Family and Community Development announced that efforts are being made to amend the PWD 2008. And just recently, sometime in January 2013, the Minister, Datuk Seri Nancy Shukri, has made comments or commented that amendments are currently being made, and amendments will focus on the enforcement and empowerment of the disabled groups' rights. And this is expected to be finalized by June 2023. So that's the latest development on amendments being made to the PWD 2008. All right, thank you everyone, and that's all from me. I'll just pass the floor to Anne for her to share her experience.
Thank you so much, Gan. Wow, I learned so much from Thulasy and from Gan. And my presentation or my sharing is really going to be as to how has the laws, mental health, and also the Act, and also the Persons with Disability Act, and how much has it done for persons with disability based on an experience level. And Farisha will be helping me to share the slides. And also thank you very much to the team of LexisNexis for organizing this. It is so much needed because a lot of families with persons with disabilities, they don't know that this is there, that this is out there. And I think the bigger question is like, how do we get all this very important information out there to them? Because sometimes, you know, if it doesn't really concerns us directly, we don't take the effort to actually learn our laws. Yeah, thank you, Farisha. Okay, we will go to the next slide. In our country, we have 7 categories of persons with disabilities, just to echo on what Gan was saying just now. So we have the hearing disability or impairment, visual or impairment, speech disability or impairment, physical disability or impairment, learning disability, mental disability or impairment. And then we also have rare disease, on also multiple disabilities or impairments. And as you can see, this is from the welfare department. And the next slide. Now, these are Malaysians, persons with disabilities. Now, on your left, she's Aisha, and on the right, I will not mention her name. Now, why we're showing you pictures of persons with disabilities? Simply because for you to actually connect with them, as they say, you know, a picture paints 1,000 words. Now, I'm just going to go through the pictures and then I will give you a story about them so that we can, together, we can see whether the laws favor them or it does not favor them. And the next picture is on your left is a young teenager on a wheelchair. She has cerebral palsy. And the young teenager on your right, she has a condition known as vitiligo, bullied badly in school. People used to call her a brown cow. She was literally living under a shell. She's also went through a lot of mental health issues. She is getting better now. And look at the next picture. On the left is a person who has global developmental delay. He has a learning disability. And on your right is a young man who has autism. And the next picture, please. This is Yuan, and they both have Down syndrome. And as you can see, we recently had an awareness campaign and advocacy campaign, and we used fashion to actually raise the awareness. And she's holding, you know, as what Gan was, you know, talking about the conventions on the rights of persons with disability, relating to the Act. And Article 7 speaks about access to justice. And are they really getting it? Are the families really getting whatever that is, you know, meant for them? Are we really ensuring that children's rights, or rather human rights, are being executed to its fullest level? I mean, sometimes if things happen to us, we know where to go, and we can get assistance. But families with persons with disabilities, at least the families I've dealt with, they go through so much, and it's just that sometimes it comes to a point where they say, you know what, we don't know what to do. As Thulasy mentioned just now, and she showed us all the data as far as the personnel related to persons with disabilities, we don't have enough in this country. So what will happen to all these people whom you saw just now? That girl, Farisha, if you could go back to our second slide, if you don't mind. Yeah, okay, this one. The girl on the right, she's deaf. And, can she get the services that has been mentioned, the access to go to places, or are your companies, all of you, who's listening here, are your companies ready to get them into employment? We spoke about fair employment for them. Are we trained to do sign language? Can we speak their language, or is it compulsory for them to learn our language? So these are all questions I think, we always ask our young people who actually come to our program, because they are policymakers from the different disciplines of education, to start thinking about how do you in your workforce ensure that the act and the mental health of these people are not denied. And we'll go to the other slide, Farisha, please. The next one, the next one. This is a friend of mine. Her name is Masita, and she's a school teacher. She's a school teacher in Seremban. And most recently, that was about 2 weeks ago, she underwent something very, very traumatic for her. And the next slide, you can actually read it. It's a letter from her to the various people. I'll just give you a minute or two to actually read this. I think time is not on my side, so I believe the slides will be shared, so you can always read it. But I'd like to really talk about the last paragraph, and she talks about, saya guru OKU buta yang sedang mengalami isu diskriminasi di tempat kerja. And we spoke about to ensure that persons with disability get the right employment. They're not discriminated. And the laws that we have, to some extent, it favors them. But how much do the school system or the various relevant agencies know about this? And because Masita was not born blind, therefore, I believe in my conversations with her, she said that she has gotten enough support to actually build courage to go see the necessary people. But if you look at her last sentence, or she says, saya amat kecewa dan terkilan kerana tidak pihak yang sudi membantu. And this is about 2 weeks ago. And so we will go to the next slide. This is a very famous case about Ahmad Zikri. He has autism, and in 2018, one day before his birthday, he was seen to have molested a girl. And I think it really created a lot of attention as far as nationwide was concerned. And, and because of Ahmad Zikri's case, the police have come up with an SOP now, as in how do you deal with someone who has a disability, and the kind of how do you speak with them, how do you deal with them, and things like that. But has these SOPs been shared with the relevant agencies? I'm not sure if if any one of you here has even seen this. And Ahmad Zikri was put in the lockup for a day. And there were a lot of issues that were actually, going on with him. Was it fair that he was given such a treatment? He has a disability and he did something, but putting him in jail for a day, what do you all think? We have the act, which was very nicely shared by Thulasy and also by Gan, as in, persons with disabilities. But is there a merge? Is there a point where this acts actually work for someone with a disability? Ahmad Zikri, after he was convicted, thankfully a lawyer who did his case understood him, and he could explain it to the judge as to why he should not have been detained. And well, the lawyer who actually assisted Ahmad Zikri's case is no longer around. He had passed away since. But what he did was a very important thing for the mother. Which mother would want to see her son who has a disability? He's nonverbal. He's mentally challenged as far as communication skills are concerned. But how did the law favor him as far as his mental health, as far as the mother's mental health? Did the authorities, I know we are short-handed, but was there enough services that was delivered not only to him, but to his mother, who is his primary caregiver? So I like to actually challenge all of us here. These are questions where most people do not look into. And let's ask ourselves now, as in, how can we make it a better place where the laws of the country, our commitment to persons with disabilities, and our Mental Health Act, how can we get all this information to the nation? How can we get it to the families of persons with disabilities so that their life would be a little bit better, because they know what are the services that have been there for them. So these are my concerns as to all those people which you saw just now, all those photographs. They're all Malaysians, and they go through some sort of bullying, some sort of discrimination. It's real. It's really, really real. And Ahmad Zikri's case, thankfully, is according to the letter which the lawyer received from the police station, was there's no further action on this. But the fact remains, during that time, the stress for his family, Masita, that school teacher who's blind, still undergoing stress. Her case has not been resolved yet. So these are all real cases, real stories that we get, that we deal to. And we can only hope and pray that they get the right attention from the lawyers and from the system. And the next slide is about, I don't have a slide because my time's up, and it's all about what can we do as a community? How can we, build a bridge so that the necessary information can be conveyed to these people? With that, I want to say thank you for listening. Back to you, Farisha.
All right. First of all, I would like to say thank you to all our speakers today for sharing your perspective about the law, as well as for providing real life examples. I think it is a very vital thing for us to hear today, which is why we have decided to hold the session. We actually received one question, which is, are there any laws or incentives provided by the government to help OKU seek employment as well as healthcare? Would anybody want to take that question?
I can take that actually.
Okay, go ahead.
Okay. As far as healthcare is concerned, if you have a OKU card, it's free for you, regardless of the condition, but it has to be in a government hospital. And 3 years ago, FWD Takaful has actually come up with a medical plan for them. It's the first in the country, because before that, persons with disabilities were not allowed to insure themselves. So that was another concern that a lot of the families had, because sometimes you want to get services in private hospitals. So FWD has come up with a policy for persons with learning disability, and they are going to be launching another product for persons with Down syndrome. So which is good, which is really, really good. And why it took them a long time, and I'm sure a lot of questions there. Why not for someone with cerebral palsy or with and other conditions? As Gan mentioned just now, we don't have enough data to actually support them. So it's really hard for them to actually convince the Ministry of Health, Bank Negara, that we need this kind of policies. And as far as employment is concerned, persons with disabilities, if they are being employed by any officers, the government does give a certain allowance for the employers to actually ensure that these persons are being employed. But then again, you want to ensure that whoever is looking for a job is capable of doing the job. Otherwise, the mental health issues will be there. And you also want to make sure that the employers know what they are in for when they are going to be employing someone who has a disability, to really understand what the person is. That's why we look for job coaches to actually come in there. Like in the US or in the UK, they do ensure that a job coach is there with the persons with disabilities, so that both parties can actually get the maximum out of this situation. I hope that has answered your question. Thank you.
Thank you for the answer, Anne. Gan, Thulasy, do you guys have anything to add further to that?
Not from my end, Farisha.
Not so much as commentary, but I think one thing that I sort of echo the way Anne structured her presentation is that I hope this session has raised questions in the participants' minds, because there aren't many answers. I think what we are trying to do and what LexisNexis is achieving with this session is to raise awareness. And I hope the participants walk away, at least those of you who are not familiar with the challenges having to be endured by some of our citizens who have either a mental disorder or qualify as persons with disability. And how I think we all owe them a duty to sort of create this awareness and do better by them, I guess. Thank you again, Farisha and Roshni.
All right. So now it's already 4 o'clock. So I believe that it is actually a good time for us to end today's session. On behalf of LexisNexis, I would like to thank our panelists today for participating. And I hope that all the listeners who dialed in today, thank you so much for your time as well, for the day after a long holiday. Thank you so much for tuning in. And I hope that, as everybody has mentioned earlier, you carry something into this, from this session into your daily lives. And let's just try to make our lives and other people's lives one day, a better a day at a time. Thank you guys so much for today.
Thank you.
Thank you. Thank you, everyone.
Thank you. Thank you, everyone.